Welcome everyone to this second instalment of our bite-size webinar session. Right, let's get started. So the topic for this bite-size webinar is overage. This is obviously a very large topic to cover in the space of half an hour. So we're just going to focus on the fundamentals and the common pitfalls associated with overage and overage clauses. Please feel free to raise any questions as we go through. We may not have the time to deal with these during the course of this webinar, but we will follow up with responses in the coming days. So my name is Timothy Wheen. I'm a partner in the property development team here at Fidancy, and I'm joined by my colleague Becki Biscoe in our real estate disputes team, who will be discussing and interjecting with a few important legal cases on overage during the course of this session. So without further ado, let's crack on and get started. So what is overage? Probably the obvious place to start. So overage is a future payment to be made to a seller if certain conditions are met. Typically, the seller wants to share in any uplift in the value of the property after completion. So as overage is a future payment after completion, there is some element of crystal ball gazing involved when drafting and negotiating overage. Getting the drafting right can be hard, as the parties have to consider all reasonably foreseeable circumstances in order to ensure that the overage provisions remain effective for the whole of the overage period. If we have a quick look at the kind of main types of overage then, overage is a pure form of contract law. There are no limitations or scenarios or limitations on events that could result in overage being paid. If there's any opportunity to secure additional payments, then the parties may want to consider an overage clause. However, the most common types of overage payment are set out there on the screen, and they're as follows. Anti-embarrassment overage. So this is the onward sale of a property in its present state, where the seller fears that a buyer may take advantage of a rising market in order to make a quick profit from the land, or indeed that the buyer purchased the land and flips it straight on to another purchaser for a big profit. It's also used in a case where a seller is anxious not to be embarrassed by being seen to have sold the property at less than its market value. In particular, public sector bodies and charities are required to sell at best consideration that can reasonably be obtained, and therefore they often seek to include anti-embarrassment overage protections to try and ensure that they can meet their legal requirements. Another type of overage is the grant or implementation of a new or improved planning permission. Obviously, on the grant or implementation of a planning permission, there is potential for substantial increase in the value of the property, and the seller may be keen to get their hands on a share of that uplift. Sales overage or profit sharing. So this is where a developer anticipates selling residential units for, say, an average of £300,000 per plot. But because of a rising market, by the time the developer actually gets to sell the units, they can sell them at an average of £350,000 per plot. In that case, the seller may try to negotiate an overage on this so-called super profit that the developer has made. And then finally, another common type of overage is the removal of an impediment or the rectification of a defect. This could, for example, be the removal of a restrictive covenant or the rectification of a highways issue. By rectifying that defect, the value of the land may be substantially increased, and again, the seller would like to share in the uplift in value that has created. So those are some typical examples of where and how overage is used. So we're now just going to do a quick run through some of the key elements of an overage clause. What are the fundamentals that we're looking out for? The first is a simple one, it's duration. The duration of an overage clause normally depends on the nature of the event that will trigger the payment and the likely timescale for that to occur. So if land, for example, is being sold to a developer who is going to immediately apply for planning permission, and overage is based on that planning permission, then perhaps an overage of 5 years would be sufficient. However, if land is being sold within the Greenbelt and it may not be available for development for perhaps 20 years, then clearly a much longer timescale will be needed. So the next, so that's the duration element of an overage clause. The next fundamental element is what will trigger the payment. Classic examples are the grant of planning permission. Planning permission has been granted, which increases the value of the land. The parties in that case will need to consider what actually will trigger the payment. Will it be outline planning permission, detailed planning permission? What happens if planning permission is granted but then is subsequently revoked by virtue of a successful judicial review challenge? So there's a little bit of additional thought that needs to be considered when the trigger is going to be granted of a planning permission. The alternative is implementation of a planning permission. Implementation will normally crystallize any uplift in the property's value. So that can often be a suitable trigger. Developers and buyers are normally more happy with implementation on the basis that when that uplift is crystallized, that's when overage should be payable, rather than merely on the grant of planning permission, which may never be implemented. So that's often a point for negotiation. And then for sales overage, it's normally the disposal of the units, and for anti-embarrassment, it's normally the disposal of the property. So disposal of the units, sales overage is commonly payable on the disposal of a unit, each unit, or the last unit, as this is when the value of the units can be ascertained. However, there are traps here for the unwary, and Becki has a good example of this.
That's right. The trigger event is probably the most litigated element of an overage provision, and the trigger is the first thing that I would tend to try to pick apart if I were asked to advise anyone on an overage clause. There are a couple of important cases on this, and I'll apologise in advance as the developer doesn't come up very well in any of these cases, and it's a bit of a running theme, to be honest, with the courts. The court will tend to adopt a textual and contextual approach when considering any and interpreting any contractual provision, and with a subsidiary role for the principle of common sense in the case of ambiguity. And in the renewal Leeds and Lowry case, the developer was found under no duty to develop, but if it did and total sales exceeded £7.5 million, one half of the excess was to be paid to the seller as overage on the sale of the last 84 houses to be completed. The buyer developed and sold only 80 of the units and then tried to argue that overage wasn't payable. I've already hinted at the outcome here, and the court disagreed with the developer and implied a term into the agreement requiring the developer to complete and sell all 84 units if it chose to begin the development. And the court took a similar dislike of the developer in the MOD and Country Metropolitan Homes case. And in that case, the overage provision gave the developer a get-out clause, allowing it to build out a large part of the site overage free if it demolished 37 dwellings on another part of the site. The developer demolished 35 houses and turned the last 2 into a shop to comply with the planning condition. The court wouldn't allow the developer to take advantage of the get-out clause and adopted a very strict interpretation here. And I think the overarching takeaway must be that the courts won't imply terms into agreements just to fix a bad bargain. So it's really important to pay as much attention to your crystal ball as possible when you're when looking to draft an overage clause, to ensure that you're covering as many future events as possible.
Thanks, Becki, and that's absolutely right. Another example of where we can put in drafting to ensure that doesn't happen is, if we've disposed of 80 out of 82 dwellings, but overage is only payable on the sale of the last dwelling, then as you get to the end of the overage period, we could include a provision where you have deemed disposals. So those last 2 units in that scenario were deemed to be disposed at market value, therefore triggering the overage. So as Becki says, the trigger is a hugely important point that does need to be considered very carefully. Okay, so the next element of an overage clause is obviously fairly fundamental, which is how the payment will be calculated. So typically there's a market valuation or there's specified amounts. So there could be fixed sums per additional square foot over the anticipated planning permission, or a simple market valuation exercise as well that can either be agreed between the parties or determined by an expert. You also then will have allowable deductions and permitted incentives. So where there's a planning overage, and say the planning overage is going to be split 50-50 between the developer and the seller. If the developer has applied for and incurred the cost in obtaining a planning permission, then normally the cost of obtaining that planning permission would be deductible. And an example of a permitted incentive is where, say, on a sales overage, you're selling a unit, the headline sale price is £300,000, for example, but the developer has offered incentives to plot purchasers, such as they will pay the stamp duty or they will provide additional white goods. And those kind of permitted incentives, those inducements, should then be reflected in the formula for calculating overage. Unless the overage is really simple, it is, I think, always a good idea to provide a mathematical formula for any calculation. If it's particularly complex, you may also want to consider including a worked example within the contract. While we accept that overage provisions can be complex, there's always a danger of just making overage provisions far too complicated for anyone other than the mathematician to understand. So if you end up with an overage calculation looking a bit like this one on screen, then I suggest you may want to reconsider the clause. And indeed, Becki, I think you've got a good example of this.
Yeah, I think they had something that looked a bit like this in the George Wimpey case, actually. That one's a really useful illustration of parties that just have gotten a bit too involved in the numbers. Both parties in that case made a mistake with the calculation, and the court found that it was too complicated for anyone to understand and needed to rectify it. The Court of Appeal again found against the developer, again, sorry, running theme, as it felt that Wimpey was the stronger of the two parties because of its resources and experience in the field of residential development. So again, just more factors to bear in mind when thinking about preparing these really complicated provisions.
Absolutely right. And listen, we all appreciate that overage can be complex. There are often multiple heads of overage, how everything works. But there comes a stage where if you need to be Stephen Hawking to figure out the overage, then someone's taken a wrong step somewhere, I would suggest. So for a bit of fun, and if I could ask you to get a pen and a bit of paper, I'm going to ask you to quickly carry out an overage calculation yourself. So on the screen is an overage formula for calculating an anti-embarrassment overage. Don't worry, there won't be a test, just a bit of fun. So under this overage scenario, the buyer purchased a property for £3.8 million, is now selling the property for £5 million. Anti-embarrassment overage applies, and we've also listed a number of deductions that need to be made, and of course the formula is at the top of the screen there. So let me leave this on the screen for a bit, and I'll give you a minute or so for you to scribble down some calculations. Again, don't worry, it's only a bit of fun, but once you have your answer, then we'll put up a poll in a minute or so, and you can select what answer you think it's going to be. Okay, don't worry if you haven't finished, but we're now just going to put up a quick poll on the screen. So either take a stab in the dark, or if you've managed to calculate it, let us know what your answer is. I've got a bet that answer 4 is going to be the most popular. Oh no, okay, great.
Oh wow.
There's the poll on screen. So 46% of you are correct. 185,000 pounds is the overage calculation. Don't blame the people who ticked the last couple of boxes. So let me show you just briefly how that was calculated. Apologies for giving you such a short period of time. So that's the calculation: 5 million less, which is the sale price. 3.8 million is the original purchase price plus costs. Put that all together, times it by 50%, and you get anti-embarrassment overage of £185,000. So we've got clearly some sophisticated people on the call for doing that so quickly. Right, well done. Moving on to other key elements of an overage clause. So just a quick one here. Will making the payment release the obligations? So sometimes an overage payment will be a one-off payment arising from a single event, in which case payment will or should release the obligation. However, the overage payment may also continue even once an overage payment has been obtained. A classic example would be an improved planning permission. If a developer obtained planning permission to construct 100 plots, more plots on the property, then an overage payment would be made under a planning overage. But then in 5 years' time, the developer obtained a second planning permission permitting another 50 or 100 units. Then in most cases, the seller will want to ensure that overage is paid on each planning permission. So we just need to think about when it's going to be released, how it's going to be released, and the mechanisms for that. The next key element is how payment is going to be secured. So this could really be a topic on its own, and we don't have time today to run through all the ramifications and issues with securing overage. However, suffice to say that it is an absolute crucial element of an overage clause that needs careful consideration. A contractual obligation without any form of security is likely to be unacceptable to a seller unless the buyer is particularly strong, both financially and in terms of reputation. The most common method of securing an overage payment is a restriction on title, which prevents the seller from disposing of the property unless either overage has been paid or other certain requirements have been met. However, the parties could also agree guarantee provisions as security, or even a legal charge to secure any overage that is payable. Becky's got a good illustration of how security can be quite problematic.
Yeah, security is really difficult, and it's something that that comes across my desk more often than you'd imagine. It is a really interesting point, which again I'm sure people wouldn't necessarily have thought that was something that we would pay this much attention to. But I'd only add that having the seller named in the certificate can be really problematic if they either go missing or they don't keep their contact details up to date at the land registry. Or they refuse to remove the restriction and either allow permitted disposal or a disposal that doesn't trigger the overage payment. You'll be looking at court proceedings for injunctions and declarations and things like that if that happens. So I'd encourage including really clear provisions that require the seller to release the restriction promptly and in defined circumstances, so that if you do have to go down that route, then you're in a really strong position.
That's absolutely right, and the issues that come across my desk as well are where that advice has not been followed, where the restriction mechanisms and the releases are causing issues at the land registry. The developer can't get their sales through, etc. So that does need very careful consideration, and it should not be treated as necessarily a kind of add-on to all of this. It really goes to the heart of overage clauses. So the last element of an overage clause are some additional safeguards that the parties may or may not consider appropriate. They're commonly used in overage clauses. There's the first one there on the list is obligation on both parties to act in good faith. The reason behind that is, we talk about crystal ball gazing and looking into the future, and what happens if something happens where it's clear that the original intention of the parties has been deviated from. So a clause to act in good faith, or for both parties to act in good faith, could seek to kind of remedy or rectify anything like that. And equally, a non-circumvention clause also provides the seller in particular with a great deal of comfort, and that's a contractual obligation on the buyer or developer not to do anything or omit anything to be done whose primary purpose is to avoid paying overage. Now, that could, for example, include the buyer or developer selling the property to a group company which doesn't have any assets and doesn't have any covenant strength and therefore avoids paying overage. Or it could be, as Becki illustrated in the previous case, where payment isn't made until the sale of the last house, but the last house is never actually sold. So a non-circumvention clause it is and can be a good way of dealing with that. And I think, Becki, you've got another good example of where that might have come into play.
Yeah, it probably would have been pretty helpful in the Gaia Ventures case, as the parties would no doubt would really appreciate something which would have made all of those issues a bit more clear cut. Really complicated factual background on that one. It's and really complicated contracts. But the main point that is interesting to us is that it's was about an overage payment of about £1.4 million. And the developer delayed obtaining planning permission because it wanted to get its own funding in place first, and in an attempt to avoid making the overage payment. The case is really well reported, as the judge at first instance commented that the primary issue in the case was establishing how hard the developer had to work to make itself liable to pay £1.4 million. And in this case, the developer didn't work particularly hard because it was trying to avoid making the payment, understandably. And again, the developer came off worse, as the court held that it hadn't used its reasonable endeavours to obtain planning permission because it had to put the seller's commercial concerns ahead of its own. A good faith or non-circumvention clause probably would have been quite useful here, as it would have made it very clear to all the parties what the major aim of the contract was, and potentially acted as a disincentive to the developer to act in a way that was designed purely to avoid paying the overage.
Yeah, absolutely right. I suppose one thing I should say, or in my view, is that these are safeguards. These clauses, they're kind of there to protect both the seller and the buyer, but they are no substitute for a well-crafted, well-drafted overage clause which anticipates any and all issues that may arise. So that clearly is the principle that we should all be aspiring to. These additional safeguards do though, or can add a kind of comfort blanket to the parties. So the third one down the list there is non-double counting clause. So this is both for the benefit of the buyer and the seller. In terms of the buyer, it tries to ensure that overage payments aren't made twice. That can often be a bit of an issue where you've got two heads of overage. So you've got, say, an overage a planning overage, but you've also got a sales overage. Well, if the planning overage is triggered because you get more units on site, then the sales overage may also be triggered unwittingly because the total threshold will need to be increased because you've got an extra 100 units. So a double counting clause there can help clarify that. And from the seller's point of view, if the developer is entitled to deduct costs, say for example planning costs or missed incentives we talked about earlier, it's important to ensure that those costs can only be deducted once and not each time. Assignment of the benefit. So it's just a quick one to say that if an overage provision is 50 years in length, then individual sellers may want to ensure that they have the ability to assign the benefit of the overage to, for example, family members. Equally, a developer may want to ensure that a group company can take over the overage responsibilities. So that all needs working through if that's a factor. And then finally, positive obligations on the developer. So often overage clauses will be factual. If an event occurs, then overage is payable. If it doesn't occur, then overage isn't payable. So it might be worth considering actually putting positive obligations on the developer to achieve the overage trigger. So if that is a planning overage, well, obligations on the developer to use reasonable endeavours to obtain planning. Or if it's removing a defect in title, obligations on the developer to remove a defect in title. Right, so for the last 2 or 3 minutes, I thought it'd be a really useful exercise, and we'll be following up after this webinar with a few kind of checklist takeaways. But we just thought it'd be useful to have some practical points, really. So running through these quickly, peer review. Always ask a colleague, friend, family member to peer review any overage provisions. You know, the more people that can look at overage, you know, with a fresh eyes, the more likely they'll be able to pick up something. And it's something that I'm very conscious of. I always ask my team to make sure that overage provisions are peer reviewed. It's just an additional safeguard. Excel spreadsheets, I find them invaluable. It's really important to check any mathematical formulas work. I use Excel or just very carefully go through the formula, make sure the brackets are in the right place. Obviously, one missed bracket or one wrong multiple line can have a fundamental impact on the end result. So really important to do that. Is it too complicated for anybody to understand? We spoke about this earlier, and Becki came up with a very good case explaining that you know, that can be problematic in itself. Consider putting worked examples in the contract to show the intention of the parties. That may go some way to clarifying the intention of the parties at the time. Security, we've talked about. Essential to consider what form of security is going to be satisfactory and the mechanisms of how that all works. Commercially acceptable terms. In my view, overage should always be commercially acceptable. I've come across a couple of recent examples where you know, the seller has insisted on if there is any planning permission, if the buyer obtains any planning permission on a certain extent of land, then 100% of the uplift in value will be payable to the seller. Now, clearly, that therefore puts no incentive on the purchaser to actually obtain planning permission. Why would it go through the hassle and the cost of obtaining planning permission when they've got to pay the entire uplift to the seller? Another good example is where, you know, a seller wants 100% of any, if the buyer manages to negotiate any Section 106 contributions down, then the seller wants 100% of the uplift. Well, again, there's no incentive then on the buyer to actually negotiate that. So I think it all should always be commercially acceptable. Always think what if. We are crystal ball gazing here. So play through as many scenarios in your head as possible. And SDLT, stamp duty, just a quick reminder that stamp duty is payable on overage. And if the overage cannot be ascertained at completion because it's conditional on certain events, then you'll need to apply to defer any stamp duty. Otherwise, if and when overage is payable, you may find a nasty surprise at HMRC insisting that you also pay penalties and interest on that overage. So conscious we're almost at our end of our allotted time. So Becki, I'm just going to hand over to Becki, who's just going to have a very quick chat about possible other ways in lieu of overage.
Yes, just a really quick point I wanted to flag that overage, as Tim's mentioned, is incredibly popular, and it's becoming more and more popular. But just a reminder that there are alternatives, and really when you're thinking about structuring a deal, to think about, you know, what is it that you're trying to achieve primarily out of this deal. Would a restrictive covenant do it, or would an option to buy back, or just simply a higher purchase price be a simpler way of structuring the main thing that you're trying to achieve?
Absolutely, Becky, and yeah, there are always other options. So yeah, if you ever need to talk about anything, please pick up the phone. Good. Okay. Well, I hope everyone's found that interesting. Appreciate that it was a bit of a blitz through overage, which is a complicated subject and probably not the most interesting subject in the world, or at least not for you. But I hope you found that helpful. We'll follow up with some comments. I see we've got some questions, and we'll follow up with those as well. And thank you all very much for attending.